Yes, Mr. Jones.
My Lords, my Lady, just to pick up on two matters from this morning. My Lord Reid asked me about the facts. I'm not going to ask you to turn to them, but you'll find them at page 10 of the record.
Yes. I've checked and it's fine. I understand it now.
I just couldn't remember which capital company
yes.
it was, yes. Secondly, my Lord Reid asked me whether the fair price could be less than the merger price, and I said yes. And another point I want to make on that is, of course, that the merger price could include synergistic benefits from the buyer.
Yeah.
And in Delaware, they exclude any synergistic benefits in value in the company, because their philosophy is that you can't take the benefit of the transaction from which you've dissented. Thirdly, I just want to make a sort of a general point about minority shareholders, which I'll come back to, but one shouldn't see them as if they're being as it were, deprived of some value in only getting the value of a minority shareholding. They will have bought in as minority shareholders. If it's traded stock, then they will have bought in with a minority discount. Even if they were the original shareholders, they would have bought in knowing that they were minority shareholders. That's the value of what they've got. And the expectation of ever getting anything more, they have no legal right to that expectation.
Could I just try and put it another way, because I was thinking about this point. The fact is that this is a take-private scheme.
It's a merger, yes.
But it's a take-private scheme.
Well, yes.
So there is no business purpose for the merger. It's a private purpose of the majority shareholders to take private.
It's a management buyout.
Yes, all right. That's fine.
I mean, it's management buyout with the assistance of outside
if there isn't
finances.
a corporate purpose, would it be possible for the court, when fixing fair value, to take that consideration into account? These are not shareholders who are voluntarily selling their shares, but who have been faced with a merger proposal and they've had to give notice because they don't agree with the price, but they're not, as it were, voluntarily giving away their shares.
Is my lady suggesting that there may be different fair values for different fact situations?
I'm only dealing with the present case.
Well, the whole legislation is that every merger will to some extent alter the nature of the company, even if what's happening is that it's going to be the surviving company. So to some extent it will always be altered. And if they don't want to participate in it, then they can dissent. So to the extent that all mergers and consolidations will involve some compulsory element to it, simply because 2/3 combine 1/3. So the mere fact that there is compulsion doesn't, it seems to me, make any difference to the principle on which...
No, that wasn't the only factor. I was saying there's no corporate purpose for this transaction. It's a take-private transaction, management buyout.
Yes.
So that may be a case in which the court can look more generously at value, because you're taking it because you want to take the benefit of all the shares as an aggregate.
Well, if my lady is saying that in this particular case, because of the fact situation, they should get a proportionate value, whereas in other cases it may be that they should get a discount, that's never been an argument that's been advanced in this case, or as far as I'm aware in any other cases. So that hasn't been explored in this case. The parties have proceeded on the basis that the fair value here is the same, if one calculates it according to the same principles that one would calculate the fair value in any other company, depending on what the particular facts are. So, my lady, I would say one ignores the present facts of this case. And that what one's got to do is work out what the term fair value is. It may be that perhaps there are variations, but this isn't a case that has explored that. And so I would say it's not a point that can be taken on here.
I mean, you're saying, aren't you, that you always apply a minority discount because by definition these people will always be, even collectively, a minority.
Well, yes, I say what you always do is to value the shares.
Yes, but you say that always involves a minority discount, where you're valuing the shares of the minority.
Yeah, yes.
Yes.
But
Mr. Crowe says you never do it, so we've got a very black and white choice.
And that's the way it's been argued, yes.
And that's how it's been argued in this, and you say all the other cases.
There aren't cases there are only two previous cases in this jurisdiction. In the first one, they didn't argue the point.
No.
They didn't suggest it was a minority discount. So this is the first case in which the issue has arisen.
I suppose if we're not convinced either that it's black or that it's white, all we need to do is decide how, whether this particular case is black or white, and possibly leave open wider issues.
Well, these issues of fact just weren't explored at first instance. I think
you would say if it's fact sensitive, then there just hasn't been an examination at either level below this level of the detailed facts.
Yes, yes. So that if you were going to come to a conclusion that each case depended upon its own facts and it depended on what the benefits were that were being obtained by other shareholders, then it would just, I suppose, have to go back for re-examination as to what sort of facts would be relevant to our case.
Yes, but you've said synergistic value is not relevant.
Well, that's my submission.
Yep.
I'm not putting it, certainly in Delaware.
This point arises irrespective of what the majority intend to do with the companies or have done since the effective date.
Yes, certainly in the Delaware statute, you've got express wording which excludes synergistic benefits. You don't get that wording in the Cayman Island legislation. And in fact, you don't get that wording in the Canadian legislation. However, Canadians take the view that synergistic value is excluded. I'm just going to give a reference to the Canadian article. Just in case you wanted to do that. The Canadian article is the Authorities Act 102, Electronic Record 4194, and then 4197. Previous Canadian legislation was in the same form as the Delaware legislation, which expressly excluded synergistic benefits. That wording was taken out. But there is a decision in Canada which says you still approach it on the same basis, because the underlying philosophy is that you put the dissenters in the position that they wanted to be in, which is they wanted to be a shareholder in a continuing company. I don't want to spend too much time on that, but those are the references which I hope are helpful.
Thank you.
We were dealing with Short and the Treasury Commissioners. Just got, if we can go to page 12 and 13 of the case, that's 2066 to 7 of the record. This is the passage by Lord Porter in the House of Lords. I haven't got time to go through it, but the point he's making is that the impossibility of adopting a uniform sharing approach when one has different classes of shares with inherently different values And of course, if what you do is to assume, well, there's actually been a sale of the business and therefore a distribution of the proceeds on liquidation, that would produce a different result. And then perhaps over the page at page 14, we've got two passages from Lord Athwart. And then Lord Athwart makes the same point in paragraph 53 of our case that we've seen earlier, which is, I desire only to add that if someone shareholder held a number of shares sufficient to carry control of the company, it might well be that the value proper to be attributed to his holding under the regulation was greater than the sum of the values that would be attributed to the shares comprised in the holding if they were split between various persons. The reason is that he has something to sell control which the others considered separately have not. The contention of the appellants, if accepted, would, as the Court of Appeal point out, deny him the real value of his holding. And I say that's the consequence of the Delaware approach. I just want to briefly touch on the position of breach of duty and abuse of power, and really to make the distinction that that's not the sort of case that we are dealing with, and that if there is a breach of duty or abuse of power, then that should be dealt with separately. And we've looked at section 236.16, and perhaps we could just go back and look at that again. It's on the record at 2226 to 7. And we've seen this a number of times, and what it doesn't exclude is the right of the member to institute proceedings to obtain relief on the ground that the merger or consolidation is void or unlawful. And what we say is that unlawful there is referring to, is not just limited to criminal acts, but refers to what would be classified as unlawful in civil law, so that a breach of duty by the directors, an abuse of power by the majority. Because one has to remember, this is envisaging remedies. So it can obtain relief on the ground that the merger or consolidation is void or unlawful. And what we say is that that would include any action that could otherwise be taken by a member, including obtaining the minority oppression remedies through the just and equitable route that's available in Cayman. There is a problem overall with this legislation because, as was pointed out earlier, the consequence of registering the merger and or consolidation is that the non-surviving companies are struck off. That doesn't sit very easily with a lot in Section 238, because 238 does envisage that the constituent company, the surviving company, or the consolidating company can make an offer. So nobody's quite, I don't think any case has arisen where one's got to solve that problem. But it would be that Section 38 ought to be given preference, and that if action had been taken which was unlawful, then a remedy should be provided, and one should read it in that way. I should also say that, and I don't think there are any cases in the bundles, but in Canada, they consider that as part of the jurisdiction to put a fair value on the shares, they have jurisdiction to investigate breaches of duty. So that, but obviously that has to be specifically pleaded and proved. In America, and we've got a passage from one of the cases, they don't have any difficulty with bringing breach of fiduciary duty claims at the same time as appraisal claims.
The 16 isn't talking about situations where, for example, the conduct of directors has been unlawful. It's concerned specifically with relief on the ground that the merger or consolidation is void or unlawful. presumably that might be because of a failure to comply with statutory requirements governing a merger or consolidation under this legislation.
Well, of course, one needs the approval of the directors to the plan of merger. That's the starting point. So that if they have failed to comply with their own fiduciary duties, then that would lead to setting aside the plan of merger or consolidation.
But the breach of... I'm sorry.
I think I've finished.
I'm sorry. The breach of duty may have nothing to do with the merger. It may be something else entirely.
Well, that's, in other words, the value of the company is X. It ought to have been Y because 12 months previously, they'd misappropriated assets. The sort of situation that we have on unfair prejudice petitions. Yeah. Mm-hmm. But I think the point we're making is that you shouldn't, as it were, inbuild into the definition of fair value an assumption that something wrong has taken place. That sorry, my Lord Reed was going.
No,
I'm sorry, I thought you were...
No, but another way of putting it might be to say that one should allow the concept to be sufficiently flexible to accommodate circumstances where, for example, there has been a deliberate running down of the value of the business.
My Lord, I couldn't agree more, and I think I've made that point in my case, where what I've said is that Section 238(16) is wide enough to cover these, but even if it isn't, I would have thought that there should be some mechanism that would enable redress for past breaches. It's obviously not an issue that is before my Lords, and it would need some specific argument in relation to a particular fact situation. I think all the point I'm making is that in our particular case, there is no suggestion of that.
I think what troubles me is could you not have a merger which was intended to be immediately followed by a sale of the surviving company as a going concern to a third party, and a minority of the surviving company dissent, and in those circumstances, if they were bought out at a discount of their percentage of interest in the underlying undertaking, then the majority would take the undertaking not merely without discount, but at a value to them, which would in fact also include the discount suffered by the minority.
Yeah,
I don't know how far removed from that the facts of this case are, because as I understand it, this is the surviving company, and under the scheme, it becomes a wholly owned subsidiary of another entity.
Well, it's a management buyout. The management get in outside financiers. Those outside financiers, yes. But I think I'm repeating what I've said earlier, which is that it's been presented as a black and white answer. And even if you felt that on an examination of the facts, well, assume that there is, as it were, a discretion as to how one approaches fair value, so that some cases could be a proportionate value, some could be a minority, some could be somewhere in between. So if that's your starting point, and this case might fall within that just wasn't explored.
No.
So it would be, I would submit, unfair to, as it were, try to categorize this case according to some classification of what would be fair in other cases. But again, I come back to the point, the dissenters didn't want to go ahead with the transaction. If the transaction has been properly carried out, so be it. If the directors or the majority have abused their rights, then there should be a remedy for that.
But it's a fair inference, isn't it, from the fact that even on a discounted basis, the value has been calculated at very substantially above the offer price, that the buyer group to the extent that they are also part of the majority, are getting some reward out of the transaction that's not reflected in the offer price.
Well, can I, while you mentioned that point, actually just show how the calculation occurred in this case? You might want to start by going to the record, volume 2, divider 4. I'm taking it from the other side's experts' report so that I can't be accused of any sort of bias as to how it's been, how it's come about. Perhaps I can just set out the background so that we're short of time. What happened in the 1990s was that a lot of private Chinese companies raised capital on the US markets because they felt that they weren't getting an equal share of the equity and debt in China because it was going to the state companies. So they raised money in the US markets. There was something like about 400 companies that raised capital in the 1990s. What then happened in 2010 and 2011 was that rampant misrepresentations were found in the accounts of various Chinese companies. And when I say Chinese company, I mean it's carrying on business in China. And what you then had was what was called the Chinese effect, that there was a substantial discount for all Chinese businesses which were listed on American markets, which of course led to the enthusiasm to take them private because the share price wasn't properly reflecting what otherwise might be the value of the company. Now, if one goes to page 574. One's got the trading price of the shares in Shanda. At the top left-hand corner, one's got 25th of September 2015. That's a typo, it should be 2009, as you can see from the bottom left-hand corner.
Yes.
So it floats at something just below $12 a share. You then get 2010 and 2011, which is the Chinese effect, so that the share price comes down. And it's basically, before the first take-private offer, it's basically trading at $3 to $6 a share. In fact, the merger price is $7.10. The price before the announcement was $5.70, and it went up to $6.50 on the announcement. So that's the sort of trading range that was taking place. And the way what the expert said was, well, if you go down to 8.8 and 8.9 below it, as a general point as to the relevance of these data in the context of an assessment of fair value, there is evidence that the perceptions of investors in US markets towards Chinese companies were tainted as a result of events starting around mid-2010, thus resulting in an undervaluation of many legitimate Chinese companies in the US. I consider this limits the usefulness of the observed share prices of Shanda on the NASDAQ as to an assessment of the fair value for much of the available period. Now, of course, what they do in Delaware, which is what both the experts did here, the starting point in Delaware is to value the company's business. And what the expert said was, well, the share trading price wasn't an accurate representation of the company's business because of the discount. So therefore, they ignored the trading price. Both of them did that. So you then valued the company. Now, what has happened since in Delaware has been a substantial retrenching and a dislike for DCF analysis. If you want, there are 5 Delaware cases that have, and you'll see a useful summary of them in the 5th case, which is Solaro. And for your note, if you go to the record at pages 3000 to 3003, you will get a summary in Solaro of those previous 4 decisions, all of which are in fact in your bundles. And what the Delaware authorities are now doing is that the starting point, effectively, as you look at the trading price or the merger price, because that's what the market has assessed the value of the company. And of course, the position here is that these shareholders were holding shares in a company that had a trading range of $3 to $6. They were never going to get more than that. They had no prospect of getting more than that. If the approach, as we say, is you put them in the position they would have been in, what they had were shares of $3 to $6. But because that was entirely ignored and they did the DCF analysis, what you came out with was a company where the shares were valued at $16 odd without a minority discount and $12 with a minority discount. Well, there was never any prospect of these shareholders ever getting anything near that.
Well, so long as it was US listed. It could be listed somewhere else. It's only the taint from the US market we're talking about.
That's right, but of course, because they were dissenting, they wanted to have a company which was listed in the US market.
No, but they were giving the majority the facility to go and list elsewhere.
They were, and if that, if what they were doing was not acting in the best interest of the company, then that's the remedy that you directed at, rather than, as it were, trying to build that into the share price, because all they had was a $3 to $6 trading range. Anyway, I'm sorry that distracted, but the question was raised as to how you get $16 and $12 in this case. And what I say is that you mustn't imply from that that they've done something wrong. Because also, if you look at, if I can quickly identify the paragraph that I've put in the where it is in my case. What you have here is you set up a special independent committee, you get outside professional advice. Yes, if you go to record page 2084, paragraph 105 of the case, I've just noticed the time, I've really got to move on, but this sets out the whole process of the independent advice that they got from Merrill Lynch. So this was all done properly, but I have to...
I don't think there's any suggestion that there'd been improper behaviour.
No, that's right.
So I think you may be down a bit of a rabbit.
But what I don't want is that, as it were, you approach the calculation of, or the concept of fair value,
Yes.
as if there has been some wrongful conduct here. Now, I just want to deal with the analogy with the squeeze-outs and the schemes of arrangement. And my learned friend set out the parameters, if I can just quickly summarize them. With the squeeze-outs, if an offer is made for a class of shares and 90% in value accept, the offeror can compulsorily acquire the remaining 10% unless the court thinks fit to order otherwise. But in calculating the 90%, you exclude shares held by the bidder. So it has to be 90% of the unconflicted shareholders. In schemes
held by the bidder,
I'm
or
sorry.
held by people who may be in a concert party with the bidder. It's a wide definition.
It's case law
Okay.
that puts a gloss on the statutory words, and is reboogle, I think, and that's in the bundle. In schemes of arrangement, at least 75% of the shareholders of each class must vote in favour, and it must be sanctioned by the court. And in constructing the classes, the conflicted bidder will usually be excluded so that it's in effect necessary to get 75% of the unconflicted shareholders. Of course, a merger or consolidation has less hurdles to overcome. The conflicted members are permitted to vote, and a special resolution is passed with only 2/3 of those voting. Now, it may well be that the quid pro quo for permitting, in principle, those with a conflicting interest to be able to vote on the proposed merger or consolidation is that those who dissent have a right to have their shares bought out at a fair value determined by the court. I don't have a problem with that. That explains why you have the court determining the fair value. However, we say it does not logically follow at all, simply from the fact that the court is determining the fair value, that it has to be more than the value the shares actually possess. Now, the significance of the cases in relation to squeeze-outs and schemes of arrangement is this. With a squeeze-out, if 90% of the unconflicted parties consider the price offered to be acceptable, then you proceed on the basis that that's a fair price, because that's what 90% have decided. Similarly, with schemes of arrangement, if 75% of the unconflicted shareholders have decided that the terms of the scheme are acceptable, then you proceed on the basis that that's fair. But the significance of the cases is this, that the price that the 90% or 75% have decided that they're willing to take can be, and often is, less than the proportionate value that those shares have to the company. Because if somebody is bidding for a company, they're trading at a minority discount of 80, and if the bidder says, well, if I get 100%, I'll have the whole company, which is 100, what I'll do is to offer 90, so that the shareholders get more than they're ever realistically going to get from the market, and the bidder gets an uplift. However, the issue in Re Grierson was that there was a complaint, of course, by some of the minority that said, but the price that we are being offered for our shares is not equal to the proportionate value our shares have in the whole company, and that's unfair. And if we go to our case at paragraphs 132 to 133,
that paragraphs.
Paragraph, sorry, yes. It's on the record, it's 2094, internal page 40. Sorry, it's the earlier page, it's page 39, so it's the earlier page. So 132, the complaint in Grierson was that the purchaser was getting control and would therefore receive an uplift in the value of the shares acquired, but was not paying for that uplift in the price for the shares. As Mr. Justice Plowman said, then it is said that the price of 6 shillings a share does not reflect the advantages accruing to Holtz by their obtaining complete control of the company. I agree with Mr. Instone that that might possibly be used as an argument to justify paying a shareholder with a controlling interest a larger price for the shares than the price paid to minority holders. But in my judgment, it's not unfair to offer a minority shareholder the value of what he possesses, i.e. a minority holding. The same argument was put to the Court of Appeal in Prescott's case to which I have referred, and although the case did not find it necessary to pronounce conclusively upon that argument, it's quite clear that it did not find any favour with them. And the point we make is, this is the same underlying philosophical jurisprudential approach adopted in Short. It's not unfair that for a minority shareholder to obtain as compensation the value of what he possesses. And the judge later said, on general principle, in my judgment, the element of control is not one which ought to have been taken into account as an additional item of value in the offer of the shares. So that's what I urge as the traditional sort of UK Cayman approach to this issue. And one has a similar approach in Re Linton by Mr. Justice Lewison, which I can't take you to because of time. In relation to the minority oppression cases in the UK under Section 994 and its predecessor, as I said to the Court of Appeal, and I say to this committee, I urge you to be very cautious about those cases because they're dealing with unlawful conduct. And one can well see that one's got to provide a remedy suitable for the unlawful conduct, the oppressive conduct by the majority. And even though the gist of authorities, and I accept that they don't necessarily speak with one voice, but the gist of the authorities is to the effect that if you're a minority shareholder in a non-quasi partnership company, the starting point is that you should be bought out at the minority discount. I have no difficulty in seeing why that should be different if somebody is oppressing them and just taking unlawful action in order to acquire their shares. And there's a useful recent judgment of Mr. Justice Fancourt in the Re-Edwardian group where he accepted that that was a non-quasi-partnership company at the relevant time, and what he ordered the shares to be bought out was at a price that the minority and the majority would have negotiated between themselves. So it's not, as it were, a full proportionate value of the company, but nevertheless more than the minority discount. And that all seems sensible, but my basic thing is don't pay any attention to those cases in our case. We've then got the Bermuda and BVI cases. They're of peripheral importance. There wasn't the sort of argument that you've had the benefit of. There's different statutory provisions. However, I draw some comfort from the fact that throughout the, if I can call it the British overseas territory world, the UK in respect of the other authorities, there isn't this instinctive abhorrence at a minority shareholder being bought out at the price, including a minority discount. That's the value of what they've got. And it's on that point that there's a fundamental difference between the Delaware approach and the approach that I'm advocating. And if we could go to the part of the case where we've set out the Delaware authorities. So it's paragraph 139 of the case, page 2096 of the record. I've got to do a canter through this, I'm afraid. Oh, I've got the wrong page reference. Yes, it's page 2096, yes, the Delaware approach. The initial case is Chicago Corporation and Munns, which my friend referred you to in the authorities bundle. It's at volume 3, divider 36. I've quoted the relevant paragraphs. Now, it's true that the first ground on which the court did not adopt the market value approach was that there had been other legislation in other states which had used the term market value, whereas the Delaware legislature had used fair value. So they said, oh, well, it must mean something different. However, if you go down to paragraph 142, the Chancellor then said that if he had not been aided in that interpretation, he would still have come to the same conclusion that value did not mean market value. And this is the the philosophical approach in Delaware. When a stockholder buys stock, it is to suppose that he buys into a corporation as a going concern. He does not buy on the theory that he is about to participate in a contemplated liquidation of the corporation's assets. He buys an aliquot share of a business, and he probably takes into account, or should at least take into account, not alone its present asset condition and earning power, but as well as its future prospects as a continuing enterprise. When a merger proposal is put through with which he chooses to dissociate itself, he is forced out of his investment and compelled to abandon his association with a business of which he was a past owner. As to him, the going concern is done. Others have decreed the cessation against his will. What he has been deprived of is his proportional share in an active enterprise, which, but for the compulsion of others, he could continue to be associated with in the indefinite future, etc. I'll come on to comment on them. Then you've got Tricontinental Corporation and Batty. The basic concept of value under the appraisal statute is that the stockholder is entitled to be paid for that which he has been taken from him, his proportionate interest in a going concern. And the main authority over the page is Cavalier Oil. And there are two passages there which are constantly cited. The first, at first instance, from Vice Chancellor Jacob, and then over the page on appeal from Justice Walsh. And what's clear from these, I haven't got time to go through those in detail, what's clear in 149 is that they correctly recognize that the function of an appraisal is to put the dissenter in the position he or she would have been in had there been no merger. However, the underlying approach views the dissenter as a victim whose expectations of buying into a going concern business with future prospects as a continuing enterprise are unlawfully dashed by the majority, excluding him or her from future participation. The point we make in 150 is we say this is just the wrong way to look at it. A dissenter has never had a legitimate expectation. The legislature considers it beneficial for commerce that a mere majority of shareholders should have the power to procure a merger of the company. The dissenter has acquired his or her shares subject to all the rights and disabilities conferred by law and by the memorandum and articles of association. That includes a power vested in the majority to merge the company. The legislature has not provided for the consent of every shareholder to be necessary for a merger to take place. And so the only legitimate expectation that a shareholder therefore has is that the affairs of the company will be operated lawfully. If the majority decide to merge a company, the dissenter must live with it, provided it's all done lawfully. That is simply an ordinary incident of owning a share in a Delaware company. Shares are acquired with those limitations inherent in them. There can be no complaint if the process has been carried out lawfully. And I would say to view a shareholder as having a proportional share of an active enterprise misunderstands the nature of a share. What a shareholder has is the share of the share capital of the company. The company that carries on an active enterprise. The shareholder simply has a chosen action consistent of all the rights it has as against the company and fellow shareholders. So we say that this is the correct way to look at a share. It is inherently something which can be affected by the majority. And in 155, it's undoubtedly the case that the Delaware courts interpret their legislation so as to, because they perceive the majority unfairly enriching themselves at the expense of the minority. Going over to, I haven't got time to go through all the points in paragraph 49, but it is important to go to page 50. The Vice-Chancellor Laster in reappraisal said, the standard of fair value is a jurisprudential concept that draws more from judicial writings than from the appraisal statute itself. The concept of fair value under Delaware law is not equivalent to the economic concept of fair market value. Rather, the concept of fair value for purposes of Delaware's appraisal statute is largely judge-made creation, freighted with policy considerations. And we quote in 161 how Maso parties put it themselves in the Court of Appeal. There is nothing in the wording of the Delaware General Corporations Law which requires the court to value the whole company and then the shareholding as a proportion of it. I then go over the page, we then deal with the conclusions that we reach.
Just before you leave that.
Yes.
As I understood Mr. Crowe's submission, he says, well, one can look at the detail and philosophy behind these decisions, but of greater importance is the fact that the legislators in the Cayman would have been aware of this legislative scheme and the authorities under it.
Well, if one can go to paragraph 177 of my case, which can I just come to that in a moment, my Lord?
Yes.
I think with the time available,
Yeah.
if I can just quickly go through the conclusion, and I'll come to it as the point after the next one.
Thank you.
So, conclusion 2107, paragraph 174. The issue in the present case is the correct statutory interpretation of section 238. What intention can be reasonably imputed to the legislature in respect of the language and the words used? And then we go over to the point which I was going to make to my Lord, paragraph 177. As set out in paragraph 75 of the judgment of Justice Siegel, at first instance in the present case, the judge recorded that when this section was introduced, the Honourable G. Kenneth Jefferson noted, when moving the second reading of the Companies Amendment Bill in the Legislative Assembly, that this bill responds to requests from the private sector in relation to merger and consolidation provisions and reflects extensive consultation with the private sector, as well as the review of Bermuda, BVI, Delaware, and the UK legislative precedents. And what we say is, well, this obviously doesn't satisfy Pepper and Hart material. And then we go on to say 178, it is likely that the draftsman had the Delaware provisions before him or her when drafting the Cayman provisions, because they borrow heavily from the design and concepts used in Delaware, but what the draftsman thought is irrelevant, and one in fact has no idea whether the draftsman was even aware of the Delaware cases on the meaning of fair value. So what I say is, you've got to approach this statute and construe it in the way that you would construe the statute ignoring Delaware, that it's what do these words mean? And again, we're just here repeating the points that we've made throughout. A member who has a share in the share capital of the company. The fair value of the share held by the member must be determined. Member does not have a share in the company's undertaking. The words used cannot be taken as requiring the court to value the member's share of the company's undertaking, because that's not what the shareholder has. A share is a bundle of rights, etc., etc. And in 182, the purpose of an appraisal is to ascribe a fair value to the shares would have had the company continued in its existing form. On this basis, such a valuation inevitably must take into account the price which those shares might be realized for. If the price is less than the value of a proportionate share of the company's undertaking, one has to apply what is referred to as a minority discount, so be it. This is simply the consequence of valuing the shares, which is what the legislature is directing the court to do. And we say the construction results in no obvious injustice, which one might say the legislature could not have intended. The member is simply being put in the position he or she would have been in the absence of a merger. What we say is to adopt a construction which requires the minority discount to be ignored, or which requires some proportionate shares of the undertaking of the company, results in the unworkability and injustice and unfairness identified by the House of Lords and the Court of Appeal in the Short case. What I've tried to do is to look at how does Delaware deal with different shares having different rights? How does it deal with preference shares? Because its formulation of starting with the value of the company simply can't work on that. And I haven't been able to find an answer. There's so much authority that there comes a point when it just doesn't become worth carrying on with it. And I thought, well, I'm sure if there's an answer, the other side will come up with it. But they haven't.
For a valuer.
but the other side haven't come up with it. They haven't explained all these inherent problems in the Delaware approach. And what we say is that as the Court of Appeal in the present case said, one can take the law of squeeze-outs and scheme of arrangements to be the same in Delaware as it is in the UK. And the importance of those cases is that there is no requirement under these mechanisms that require that a minority shareholder should receive a proportionate share of a company's undertaking. The important point is it's not perceived to be unjust or something that has to be corrected for a special purchaser to obtain a greater value by acquiring the whole share capital. I'm going to move on to the interest appeal unless I have questions on that. I think on my friend's calculation I have 20 minutes to deal with the interest appeal. Now, in relation to interest, we say that where a claimant has become entitled to a sum of money but has not received that sum of money, the underlying principles on which interest is calculated have long been settled in England and Wales, and we say that the Cayman Islands, and that these principles are equally applicable and should be applied in calculating the fair interest under section 238(11, because they are simply sound and obviously correct principles. Now, the function of an award of interest is, in these circumstances, where money hasn't been paid, which ought to have been paid, to compensate the claimant for being out of the money. It's not to disgorge the benefit received by the defendant. That's been long established in our jurisdictions. And in calculating the compensation, one proceeds on the basis of two fictions. First, that the claimant has used an equivalent sum of money for some purpose that it would otherwise have used it for. Second, because the claimant did not have the benefit of the money it ought to have had from the defendant, it had to borrow an equivalent sum. That's why the amount needed to compensate the claimant for being out of the money is therefore the cost of borrowing the equivalent sum, which is why the claimant is traditionally awarded interest at the claimant's own borrowing rate. Except there may be particular circumstances which dictate a different solution. But what I've set out is what is the generally accepted starting point, and we need some justification to depart from it when dealing with interest which is due upon a sum of money which is payable but not paid. I entirely accept that those principles have been worked out largely under the jurisdiction conferred in England and Wales by Section 35A of what is now the Senior Courts Act 1981, but there's nothing in that provision that dictates the principles upon which interest is awarded. That provision merely provides the jurisdiction. The principles have been developed by the courts, and they are obviously sound principles. Now, Section 35A has been substantially reproduced in the Cayman Islands in Section 34 of their Judicature Act. And within Volume 1 of the Authorities, and Section 34 is Divider 11, the record is 2247. And that's Section 34, and needn't take you to 35A. For those who are familiar with 35A, it's in very similar terms, but it provides for a maximum interest rate in accordance with what's said to be the prescribed rate. That's the difference in the Cayman Islands. And Section 38(11), if we can just briefly go to Section 238, which is behind Divider 8 in Volume 1, and it's at 2225 of the record. I have to make these points because my learned friends in their case seek to make a point that somehow this is different to a case where a creditor is entitled to a sum of money which isn't being paid. And the way it works, and we're now very familiar with it, but I think it's under 7, subsection 7.
I'm so sorry, which page are you on?
2225.
Thank you.
Upon the giving of notice of dissent, the member to whom the notice relates shall cease to have any of the rights of a member, except the right to be paid the fair value of his shares. So it's at that point that the right to have the fair value accrues. Then, of course, we've seen in 8, the parties have to try to agree a price. If they can't agree a price, the court comes up with a price. And then subsection 11, at the hearing of the petition, the court shall determine the fair value of the shares of such dissenting members as it finds involved, together with a fair rate of interest, if any, to be paid. In my learned friend's case, they quote fair rate of interest. They say it's an entitlement, but they don't go on to see the words if any. So it's plainly discretionary, and if you've got a case where an offer has been made which is higher than the price subsequently determined, you can well see that the court in its discretion may not give interest. But it's plainly discretionary rather than an entitlement.
Well, it could just be saying that a fair rate of interest is nil.
Well,
if it's discretionary, don't you have different problems?
such...
Appealing against a discretionary determination?
Oh, you mean in relation to my appeal?
Yes.
Oh, my appeals are based on a point of principle. Because,
well, you just said it's discretionary.
well, I say I'm happy to accept it's discretionary, and I say that on discretionary, the usual appeal grounds for discretionary decisions, the court of first instance went wrong.
Your point, for present purposes, the point you're making really in response to the respondents is that there is an entitlement to be paid the fair value on the giving of a notice, and therefore, once the court determines what it was, ex officio, you've been out of that money for a period of time.
Yeah. Now, the way that the judge calculated the interest was as follows. He took a figure that would compensate the dissenters for being out of their money. He then took a figure that would disgorge the benefit obtained by Shanda in having the use of the money in the interim, and he then comes up with a figure halfway between. Yeah, it's difficult to imagine a more unprincipled approach to calculating interest. That, however, is how they do it in Delaware, or they did in Delaware before they altered their legislation so that they had the equivalent of the judgment rate. So the starting point is that there is no principled basis for this particular interest figure. Now, as regards the figure to compensate the dissenters for being out of their money, he awarded them a rate that they would have obtained had they invested in investment-grade corporate bonds, which was 5.09%. And of course, what we say is, well, that's not the basis on which one calculates the rate of interest. It should be the borrowing costs, because they could have invested in investment-grade corporate bonds. Failure to pay the sum of money did not cause them to fail to invest in investment-rate corporate bonds. What one proceeds on is the fiction that they have done what they would have done, but that they needed to borrow the money because they didn't get the money on the due date. And we say the disgorgement of the benefit forms no part of an award of interest designed to compensate the claimant for not having a debt paid on time. The figure that they used to work it out was the evidence that Shanda had put forward as to the prime lending rate used by the Cayman National Bank, which was 3.5%. In terms of the relevant authorities, there is the recent decision of the Supreme Court, which we have set out. Relevant. It's divider 7 in the electronic bundle 1. This is the Shanda case on interest. So it's page 2 and 3 internal, pages 2019 to 2020. And we've quoted passages from the decision of the Supreme Court in the Prudential Assurance case. As to the basis on which interest is payable, a clear explanation was provided by Lord Wright, a judge who was well aware of unjust enrichment and had also had to consider interest as a member of the Law Revision Committee, which reported in 1934. In Riches, he said, the essence of interest is that it's a payment which becomes due because the creditor has not had his money at the due date. It may be regarded either as representing the profit he might have made if he had had the use of the money, or conversely the loss he suffered because he has not that use. The general idea is that he's entitled to compensation for the deprivation. In paragraph 77, the claim to interest is not based on unjust enrichment, but on the failure to pay a debt on the due date. So we say that as a matter of principle, taking into account Shanda's benefit is not the correct way to approach this. And then secondly, we've got the well-known passage of Mr. Justice Stein, as he was, as to the principles on which one calculates the compensatory element of interest, and that is at Authorities 551, page 270. Have I given the wrong page? 3270?
3270, I think.
I'm sorry. Okay. 3270.
Yes.
It's the bottom paragraph on that page. The issue of the appropriate rates of interest must now be considered. The selection of an appropriate interest rate is a matter of discretion, but is not an entirely open-textured discretion. A practical and consistent approach has emerged. The purpose of the award of interest is to achieve restitutio in integrum. The inquiry does not focus in a case such as the present on the profit to the defendant of the use of the money. It's directed to an estimation of the cost to the plaintiff of being deprived of the money which he should have had. But for practical reasons, courts will not allow an inquiry into the plaintiff's actual loss. To do so might sometimes involve inquiries in relation to the ancillary relief of interest approximating the length of the trial. Instead, in cases such as the present, the courts award a commercial rate of interest, or the rate which somebody in the position of the plaintiff would have had to pay to borrow the money. In the interest of a cost-effective administration of civil justice, the courts must adopt a fairly broad-brush approach to the award of interest. On the other hand, in the light of the overriding criteria of fairness, the courts are vigilant to ensure that the broad-brush approach does not become too blunt an instrument. He then turns to the issues in that case, and he then quotes the well-known passage by Mr. Justice Forbes in the Tate and Lyle case. Now, I feel satisfied that in commercial cases the interest is intended to reflect the rate at which the plaintiff would have had to borrow the money to supply the place of that which was withheld. I'm also satisfied that one should not look at the special position in which the plaintiff may have been. One should disregard, for instance, the fact that a particular plaintiff, because of his personal situation, could only borrow money at a very high rate, or on the other hand, was able to borrow at specifically favourable rates. The correct thing to do is to take the rate at which plaintiffs in general could borrow, etc., etc. So that's a well-accepted basis on which one calculates interest. Now, I entirely accept that there are two important differences between section 238.11 and the section 35A and the section 34. First of all, First of all, there is no express reference to interest being awarded as simple interest. That appears in section 35A and in section 34, but doesn't appear in section 238.11. And there is no cap on the rate of interest that can be awarded under section 238.11, whereas there is under section 34. So those are two differences, but we say that...
Surely the main difference is the word fair. What value do you submit we should give to the word fair, which the Cayman draftsman has insinuated into this provision about interest? It's not, I think, even in the Delaware interest provision.
It is. It's taken from Delaware.
It is?
It's the same, yes.
Very well.
Yes, yeah. Well, I'd say that a fair rate of interest is no different. It's not as if other rates of interest are unfair. The principles on which one calculates interest is to give fair compensation to the claimant for not being kept out of the money. I don't think one adds anything to the use of the word fair.
Very well.
And, you know, the basis that of the borrowing costs is also embedded in Cayman legislation. And we can take that up. At paragraph 9 of the case on interest, where we refer, that's 2020 to 2021, and the Brevin passage is from Mr. Justice Jones, who himself had been a member of the Rules Committee that sets the prescribed rates, and he said the prescribed rates applicable in this jurisdiction are fixed from time to time by the Rules Committee for a basket of different currencies using the following formula, and essentially it's 2 percentage points over LIBOR. So they've set as the maximum a particular borrowing rate in there. Now, we need to quickly just look at the reasons why the Court of Appeal did not follow the traditional approach to the calculation of...
I'm sorry to interrupt, but it has struck me that the passage you quoted from Bonkeys-Ullman, Mr. Justice Stein, talking about the discretion as to rates of interest. It's a passage, well, it's the page you showed us, 3270. The very bottom of the page, he talks about the overriding criterion of fairness.
Yes, thank you. Yes.
In awarding rate, in determining what the rate of interest should be.
I made a note of that, but I was obviously
So it's obviously
short.
It's not only Delaware courts that
Yes.
aim to award a fair rate.
Yes. So we need to if we can then just go to the Court of Appeal's judgment. In the present case, it's Reproduced Record, Volume 1, Divider 31, and one starts I think one can go straight to paragraph 57. At page 1873. What the Court of Appeal there cites the judgment of Mr. Justice Stein, and then over the page, paragraph 58 is the single paragraph that they deal with the reasoning in their judgment. So if one goes to paragraph 58 at page 1874, I just need to take the committee through this to just show where they went wrong, or where I submit they went wrong. It starts by saying, I accept that this statement, that's the statement of Mr. Justice Stein, accurately represents the position in England. It's important, however, to appreciate that it is a statement about the principles to be applied in assessing interest on damages. Well, I can make the point there that, of course, it's not just limited to damages. It includes debt or claims for unjust enrichment. So that's wrong. Then it goes on to say, such an assessment can, of course, be made only when damages have been awarded, and damages can be awarded only when some right of the plaintiff has been infringed. The purpose of an award of interest would be to ensure that the plaintiff is put back, so far as money can, in the position he would have been in had his right not been infringed. That inevitably places the focus solely on the plaintiff. It is only his position that is of relevance. A Section 238 determination, however, does not proceed on the basis that any right of the dissentient shareholder has been infringed by the company. The legislative concern is not to restore him to the anterior position, but to ensure that he receives fair value for what he is obliged by statute to give up. In my view, that has the effect, when it comes to an assessment of the fair rate of interest, of removing the entire focus from the dissentient and instead placing it on the entirety of the circumstances. When those circumstances are considered, it is right to say, as the judge did, that both the disadvantage to the dissentient and the advantage to the company should be taken into account. Now, with respect, it's difficult to understand the logic of that. It's not understood how it can be said that the legislative concern might be to ensure that the dissentient shareholder receives fair value for what he is obliged by statute to give up, leads to the conclusion that the rate of interest payable for the delay in paying that fair value somehow shifts the focus solely from the plaintiff, as in the case of debt or damages, to the entirety of the circumstances, so entitling the court to take into account the advantage the company has received by acquiring shares without paying for them. These are two separate issues. The first is the amount payable for acquiring the dissentient's shares. The second is the sum that should be paid to compensate the dissenter for not receiving that amount at the time of the merger. The compensation should be calculated applying the usual principles that govern an award of interest, and the reasoning of the Court of Appeal, in our submission, cannot be sustained. And that then leaves the question as to, if you're with me, that the principles on which the judge at first instance applied interest were the wrong principles, and the question is what interest should be applied on the traditional principles. And because there'd already been a previous decision in Reintegra, what happened at first instance was that the parties just assumed that was going to be followed. And so there wasn't any evidence of the dissenter's borrowing rate. No point was taken on the Court of Appeal that we couldn't take this new point, even though it hadn't been argued below. So the question is, if you're with me, what do you now do? We say you should just take the prescribed rate rather than sending it back to be remitted. However, there is some evidence of borrowing rates in the evidence, because the Shanda put in evidence of the prime borrowing rate from the Cayman National Bank, which was 3.5%. I've gone over my time by 3 minutes, and if that cuts down my time in reply, I'm going to be left with just 2 minutes. Can I assist you any further?
Thank you very much indeed, Mr. Jones. Yes.
I was going to reply on minority discount first and then respond on fair interest. And I was just going to make, if I could, a string of points in the order in which they were made by my learned friend. The first simply arises in relation to this question of how the approach that we are advocating would operate in relation to a company with different classes of shares enjoying different economic rights. And at one point, I've already explained how we submit that would work, and I don't need to repeat it. The cake would simply be valued as a whole, and then the different classes would have their aggregate values apportioned, and then the shareholders would have a rateable proportion of the value of the class in which they hold shares. The fact that Section 238 contemplates a class-by-class fair valuation is reflected. I don't ask you to go to it now, but just for your note, there's a very tangled provision in Section 239 which includes at least one triple negative and one double negative, but the very least one gets out of Section 2392 is that Section 238 is plainly available in relation to classes of shares. It says so expressly. 2392 is in Authorities Volume 1, Tab 8, and it's electronic page 2227. The actual nature of the provision under 239 doesn't matter for our purposes, but the fact that it recognises expressly a class-by-class approach is, in our submission, relevant. Second point I just wanted to respond on is my learned friend made a submission that a pro rata valuation of a minority holding would deprive the majority of their control premium, he says. Well, conversely, as we have submitted, a minority discount, and for that matter, a pro rata valuation of a minority deprives them of the uplift which they would otherwise be entitled to negotiate, absent the mandatory regime under Section 238. You'll recall the submission I made that in the absence of an express statutory regime entitling the majority effectively to force out the dissenters would not have to sell. They'd have to be negotiated out. And if they've got a dog in the manger, a value in their shareholding, they could negotiate an uplift, which could either be described as an uplift referable to surrendering their power of veto over the merger, or an uplift referable to the added value to the purchaser of requiring 100% control. By being bought out, they are losing that potential uplift. And so if, in fact, it is the case that a minority is losing under 238 its power of veto, and a majority is complaining that it is losing its majority control premium, as it happens, a pro rata valuation between majority and minority achieves a brutal justice. And that, in our submission, is a good argument for adopting a general rule of not having a minority discount. Third point, my learned friend pointed out that in a situation where there is a merger between a surviving company A, he calls it, and the expiring company B, he says the shareholders in the acquiring surviving company A would also have a right of dissent. Indeed they do, but that is not an argument against them having an entitlement to be bought out without a minority discount. In that situation, if you are a shareholder in a surviving company and you do not wish, for example, to continue to participate in the surviving company once it has absorbed another entity, there is no reason in logic or fairness why, as an outgoing shareholder from that surviving company, you should be bought out at a minority discount because you are being essentially presented with an outcome into which you did not buy in the first place. So the fact that it is indeed the case that a dissenter in the surviving company has a shareholder in the surviving company has a right of dissent is not an argument against the disapplication of a minority discount.
I'm struggling to understand why, take a situation where there's a merger by big company A, which is absorbing very small company B,
Yeah.
And all shares in big company A are quoted on a stock exchange, and all the shareholders, or most of them, buy in or sell out, and that's their expectation when they take the shares, and that quotation includes an element of minority discount. But why should the fact that a shareholder doesn't particularly like this proposed merger of little company B make any difference to his expectations as a continuing shareholder in company A, which is the surviving company anyway, so as to give him something more than he would ever have got by the exercise of such powers as the shares give him?
Lord, the answer to that, and indeed the answer to a separate point that the learned friend made, he says, well, one can assume that a shareholder with a minority shareholding has bought in at a discount, and therefore there is no unfairness in valuing him on the way out on a discount. The flaw in both of those propositions, rhetorical questions, is that they are again looking at the process mandated by Section 238 as if it is a sale of shares, and that, for the reasons we outlined at the very beginning, it is the operation of 238 is not a proxy for a share sale. Minority discount is a concept which reflects the non-marketability of a minority shareholding. It is a concept that therefore only makes sense if what you are dealing with is a sale of a packet of shares from one shareholder to another shareholder. The operation of Section 238 is not a sale in any meaningful sense of the word. It is a process by which a shareholder, in the context of a transaction which necessarily involves the entirety of the assets of the company in which he holds shares, being extinguished. And so for that reason, using the minority discount concept in relation to something that isn't a share, isn't a sale, it is, in our submission, simply a mismatch of concepts and should not be adopted.
Do you have to go that far? Can you say, well, that's our primary position, but the fallback would be this transaction was not for a corporate purpose?
My lady, that argument, as it happens, it's not the case that that we are presenting, but I can't pretend that it wouldn't be an entirely credible argument. It's not the case my client is presenting. Shortly, is in Authorities Volume 7. We've got it in the Court of Appeal and in the House of Lords. I just wanted to respond to a couple of points, and I just do need to take you to it briefly to prove the point. My learned friend's submission on Short is that the courts considered the matter from first principles. And with the greatest respect, they did not. If one goes in the Court of Appeal, so Authorities Bundle 7, tab 73, or electronic page 3961, this is the Court of Appeal ruling, and you will see from page 3967 the arguments that the court was faced with. At the very top of 3967, 4 lines down, the Crown submitted that as a matter of law, that is, as a matter of construction of paragraph 5 of the regulation, the value in every case of shares transferred, blah, blah, blah. So that's the argument for the Crown. And then after the paragraph break, the claimants, on the other hand, submitted as a matter of law, that is, of the construction of the regulation, that it's impossible in fixing, and so on, blah, blah, blah. So the submissions are both overtly being made on the basis of the construction of the regulations, and if you look at the final page of the ruling, 3970, we therefore come to the conclusion that the judge was right on the question of construction. It is overtly a decision on the meaning of the words but as between a willing buyer and a willing seller, and the ratio appears on page 3969 most clearly. In the middle of the page, the formula as between a willing buyer and a willing seller is a common one, and in our opinion, when applied to a transfer of only shares imports according to its ordinary and natural meaning the concept of a separate bargain of sale by an individual seller to an individual buyer of those shares. And in our submission, that is exactly what we don't have. The passage my learned friend would wish to get some comfort from is on the page before that, page 3968, where the court, at the top of the page, the start of the new paragraph, it said, on the one hand, that it's of the essence of the matter that the Crown is, as it's bound to do, acquiring all the shares of the company. That's true. But on the other hand, it's also the fact that the Crown is acquiring shares from a number of individual shareholders. Prima facie, as it seems to us, and apart from any special words in the regulation, each shareholder is entitled to get, and get only, the value of what he possesses. Now, it's those words, apart from any special words of the regulation, that provide the basis for my learned friend to make his submission that this is a discussion from first principles. But it just isn't, because it is perfectly apparent from what is then said that they are still talking about an arm's length sale, as between a willing seller and a willing buyer. Because it talks in terms about shareholders entitled to get what they hold, the value of what he possesses, for that is all that he has to sell or transfer. If an individual shareholder in a company owns such a number of shares in that company as gives him effective control of the company's affairs, it may well be that the value to be attributed to that holding on a sale of it as a separate transaction is a figure greater than the sum arrived at by multiplying the number of shares, and so on. I don't need to read on, but it is perfectly apparent that even though they use the words apart from any special words in the regulation, they are not talking about basic principles of company law. They are simply talking about what the saleable value of a shareholding is. If one goes in the House of Lords very briefly at the next tab, and just looks very briefly at 3980, page 3980, they say three-quarters of the way down the page, as to the alternative argument that the value of the business as a going concern should be first ascertained, and then that global sum should be divided in due proportions between the different classes of shareholders. No doubt, if the regulation had stated that the shareholders were to receive the value of their shares calculated upon their value on the sale of their business as a going concern, the appellant's claim would be correct. But to my mind, the regulation makes a different stipulation, and from that we get two propositions. One is that, obviously, the decision in the House of Lords was as much a decision on the wording of the regulations as the Court of Appeal decision was. And secondly, the speculation Lord Porter offers there, that if the regulations had said that the shareholders were to receive the value of their shares calculated upon their value on the sale of the business as a going concern, that is a much closer analogy to a merger or consolidation, which necessarily involves exactly a transfer or absorption of the entirety of a business. And on that basis, we say that what Short says that on the face of it might appear to be inconvenient from our case is in fact entirely irrelevant. And what it also says is in fact positively helpful for our position. The next point I just wanted to respond on, my learned friend said it is not surprising that the legislation doesn't use market value because there may be no market for the shares. Well, with respect, that is a purely linguistic point. Any other formulation could have been arrived at if the legislator had intended to achieve the result in short. They could have used exactly the words as in short, namely that the price should be fixed on the assumed basis that it was a sale between a willing seller and a willing buyer. So there's no magic in the use of the word market or not. It's a question of what the intention is and the use of the expression fair value that matters. Next point, my learned friend referred to certain references in the IVS and the MBCA and various other acronyms which discuss the meaning of fair value in accountancy contexts. But with respect, we would suggest that the only point that you can derive from all these other usages is the passage which he quotes. I don't ask you to go to it, but in paragraph 114 of my learned friend's case, he quotes excuse me, from the IVS, paragraph 120.1, where it says, many national, state and local agencies use fair value as a basis of value in a legal context. The definitions can vary significantly and may be the result of legislative action or those established by courts in prior cases. So, in short, what one gets from the IVS is that self-evidently there is no single universally applicable meaning of the expression fair value. It derives its meaning from the context, and so looking at accountancy manuals and guidelines and so on are not going to provide you with any assistance at all. Excuse me. Next point, very briefly, although not one you need to decide. My learned friend suggested that section 238, subsection 16, which is the carve-out in relation to challenging the validity or lawfulness of the merger or consolidation. The two responses, he says that would permit an unfair prejudice claim to be brought. Well, our answers are, first, it's not a point you need to decide. Secondly, it's not a point that really assists in resolving the issue in front of you. But thirdly, it is certainly not necessarily true, because there may be any number of circumstances in which a transaction may be unfair without the merger itself being void or unlawful. So to suggest that there is some universal panacea available by means of an unfair prejudice claim is simply wrong, and wrong in spades in relation to the Cayman Islands, which does not have Section 994 of the English Companies Act. You have to present a member's winding up petition on the just and equitable ground in order to trigger any jurisdiction in the court to order a buyout. And for that purpose, you would have to prove that it would otherwise be just and equitable to wind the company up before the court even has jurisdiction to order a buyout through that mechanism. Next point, very briefly, my learned friend mentioned what he called, I think, the Chinese factor. And to some very significant extent, we agree with him about the background, and to some very significant extent, part of the factual backstory, which you don't necessarily need to get involved in, climbed out of the bag. Because, in his words, take private transactions became more attractive because he said the share price was not properly reflecting what one might regard as the true value of the company. Well, exactly. And if you want a truly graphic illustration of that, I don't propose to take you to it, but in the reproduced record, volume 2, tab 4, page 566, there is a little chart that simply illustrates three situations comparing the trading price, the merger price, and then a relisting price. And the disparity between them is absolutely astonishing. So, my Lady Arden's point that the Chinese factor is merely a reflection of the American market's attitude is absolutely right, and it is demonstrated, if it needed to be demonstrated, by that chart very, very clearly. So far as my own friend's points on squeeze-out and schemes of arrangement are concerned, we have nothing to add to the points we made in opening. The case that we are offering is quite clear. I hope that those squeeze-out and scheme arrangement provisions contain entirely different wording and entirely different statutory structures. So far as section 994 is concerned, my learned friend very candidly said, don't pay attention to them. We say exactly the same. And on this rare occasion, we are both therefore agreed that the Court of Appeal was wrong, because the Court of Appeal did take them into account, paragraph 36 of its judgment. And so we are on that issue agreed that the Court of Appeal erred in drawing support, as it thought, for its outcome from the English case law on section 994. Finally, on minority discount, my learned friend turned to the Delaware case of Chicago and Munns, and he pointed out that it was in part based on an analysis of the nature of a shareholding in a company. We would simply offer the 3 points, which you may already have fully on board, but I'll just itemize them. The first is that, as I said in opening, the first reason why the court in Chicago and Munns reached the view that it did was because of the overt difference in language between the previous New Jersey legislation, which had referred in terms to full market value, and Delaware clearly chose a different one. The court's second reason was indeed to say that the nature of what is being taken from a minority dissenting shareholder is his participation in a company as a going concern. That is not wrong as a matter of economics. That is what's being taken. It is not predicated on a legal proposition that a shareholder owns the underlying assets, but in terms of economics, that is, in our submission, entirely a fair description of what's going on. But the third point is the one my Lord Kitchen put back to my learned friend, which is that it's not necessarily the legal robustness of the Delaware analysis that matters, so much as the fact that was Delaware case law, to which my learned friend's only answer was to say, well, the remarks that were made in the Cayman legislation don't satisfy the test in Pepper and Hart. But that doesn't really meet the full thrust of the proposition that Canadian and Delaware case law clearly was part of the context against which the legislation in Cayman the Cayman legislation was passed.
Can I just ask you, while we're on the subject of Delaware,
Yeah.
The version of the Delaware legislation that we've been given is, as at October 2018, it would be helpful for us to have, if you're able to get it for us, the version that was in force at the time when the Cayman legislation was passed, because there is a difference. The expression, we've noticed that the fair value provision in relation to interest has disappeared.
Absolutely, mea culpa, and we will certainly do that. Finally, just on minority discount, I hope you won't take offence or regard it as impertinent if I merely mention that there is one current and two pending cases in the Cayman Islands which will be informed by your decision on this. So I've just been asked to draw that to your attention. Obviously on the question of timing. The final question, though, is the question has been suggested from our learned friend that the matter should be remitted, so our submission is that that is entirely unnecessary in this case. My learned friend's position on minority discount must be, and is, and must be, that a minority discount must be applied. Because if in fact it is a discretionary matter, the Court of Appeal had no business interfering with what the judge did. The argument had already been presented, and again, I don't have time to go to it, but if you, Lordships and my lady, look in the reproduced record, bundle 4, tab 16, pages 154 and 170. Sorry, I do apologize, paragraphs 154 and paragraph 170 of my learned, or Shanda's, skeleton at trial. It was, sorry, closing submissions, perhaps even more importantly, closing submissions at trial. So that's pages 1447 and 1451. You will see that it was argued by Shanda at first instance on the basis of a question of discretion as to whether or not the minority discount should be applied. By asking this committee to remit the matter, my learned friend is effectively asking for a second bite of that cherry. He has already had every opportunity to present the arguments that he may wish in relation to the exercise of discretion. The judge took the decision he did. The Court of Appeal interfered because, as a matter of principle, the Court of Appeal thought that a minority discount ought generally to be applied, and my learned friend can only succeed in resisting my appeal if he satisfies you, as a matter of principle, that a minority discount must be applied. Turning very briefly to the...
So if we were with you, you would say we simply reinstate the judge's figure.
Exactly.
Yeah.
Because you don't even say hardly ever. I mean,
I'm sorry?
you say you never apply a minority discount.
We say, as a matter of principle, you don't. Yes, exactly, we do. On fair rate of interest, could we just make some very short submissions in the next 10 minutes? Again, the issue here, and it may be important just to remind ourselves, the issue is extremely short and narrow. Going back to the Statement of Facts and Issues, page 2014 of the electronic bundle, paragraph 23.2. The question is whether the requirement to award a fair rate of interest under Section 238 of the Companies Law requires the Grand Court to award interest in accordance with the same principles on which the Grand Court awards interest on an award of debt or damages. My learned friend's proposition is that Section 238 doesn't allow the court to do anything other than what it has to do under Section 34 of the Judicature Law. And in our submission, that is simply not a sustainable proposition. If one looks very briefly first at the legislative wording, Section 238.11, Authorities Bundle 1, tab 8, as we've seen it, page 2226, Section 238.11, talks about awarding a fair rate of interest. Now, in using that language, it is not suggesting that in other cases the court has been awarding unfair interest. But in using language which is autonomous to this legislation, it was, in our submission, clearly intending to produce a different result from Section 34 of the Judicature Law. That is to be found in tab 11 of the same bundle, or electronically on page 2247. Section 34 of the Judicature Law, in familiar terms to English eyes, says that subject to rules of court in proceedings whenever instituted before the Grand Court or the Summary Court for the recovery of a debt or damages, there may be included in any sum for which judgment is given simple interest at such rate as the court thinks fit, not exceeding the rate prescribed from time to time by rules of court. Now, in our submission, if it had been intended by the legislature under the Companies Law 238 regime, that the court must always grant Section 34 interest, that's what it would have said. By using different language, it self-evidently was intending to produce a different result and not to fetter the exercise of the court's discretion under 238 by reference to exactly the same principles as Section 34. So in our submission, the very fact that there simply are two legislative provisions demonstrate a legislative intention not to make them completely coextensive.
Did you say the exercise of the court's discretion?
We say that it is a discretionary power, absolutely, under Section 238.11, and that in our submission is, as my Lord Wilson put to my learned friend, a real problem that he faces, because the judge at first instance, exercised a discretion. The Court of Appeal has upheld that. So this is a second appeal on a point of discretion.
I was thinking of paragraph 7b of your case in answer on the interest point. It is not a discretionary remedy, rather it's a statutory entitlement.
Oh, I see. I'm so sorry. Yes, well, it is a statutory entitlement to receive the fair interest that the court considers appropriate. It's not a remedy in the sense that, it may be too condensed on the written case. When we say remedy, a remedy is an award such as damages, which the court gives in relation to a wrong done. Under Section 238, there is an absolute entitlement to the fair value and to an assessment of the fair rate of interest. But yes, we don't say that the court has to award an interest rate above 0% if it considers it appropriate. But what we did see, and just going back to 238, 8, you will recall that one of the things that the regime requires, or at least one of the things that the regime attempts to achieve, is making it not necessary for the parties to go to court, because one of the stages in the process is that the company has to offer what it determines to be the fair value. And so what we submit is that one of the important contextual issues when you're looking at the meaning of the expression fair rate of interest, one of the important elements in the 238 regime is that the legislation intended to provide an incentive to companies to offer and pay the fair value without having to go to court. Now, if companies can simply withhold a fair value, batten down the hatches, put the dissenter to all the expense of a contested hearing, but still hang on to the profits of having not paid the fair value. In other words, if the interest rate doesn't involve any element of disgorgement of profits, then that statutory purpose has not been fulfilled. So in our submission, there is the legislation does include, at least as one of its purposes, an intention to incentivize companies to pay the fair value in the first place, and not incentivize them to withhold the fair value, knowing that they can hang on to any profits that they can thereby make. So to suggest, as my learned friend does, that there is a universal rule that interest does not include an element of disgorgement, in our submission is assuming too much and is wrong.
The odd thing about this case, as I understand it, the disgorgement element produces a rate of interest which was the company's borrowing rate. The real complaint here, which produces the difference in figures, is not the disgorgement element, which would have produced the same as a conventional Section 34 approach if the judge had used the dissenter's borrowing rate.
Yes.
But he didn't. He used a dissenter's investment rate. So as I see it, the difference that actually has some economic clout attached to it, or butters and parsnips, is entirely the internal approach to what the proper rate was having regard to the dissenter's position.
Yes. Well, I mean, in a sense, one can have this debate. One can have a further debate about whether, of the elements that get taken into account, one should be looking at the borrowing rate of the company as one of the elements that go into it on the assumed basis the company would have had to borrow in order to pay the fair rate in the fair value in the first place, or whether one looks at the sort of the return rate, the investment rate that the company can be assumed to have earned by having sat on the money and not paying it over, because there are a number of different elements that can be taken into consideration. You can look at the return rate that the dissenters might have made had they had the money, or one can look at the borrowing rate that they would have had to incur, or one can look at the borrowing rate or the investment rate of the company that should have been doing the paying. There aren't any universally right answers to that. And so if one is in a world in which the legislation, A, is plainly not intending to handcuff the court to Section 34, And if one acknowledges that an element of disgorgement is a relevant element, then it is simply down to the judge's discretion how to apply that in the circumstances of any case. That is what the court said in Integra. That's what the court at first instance and in the Court of Appeal said here. With the greatest respect, the two decisions that Milan Friend has cited don't actually assist him. If I could just respond to, very briefly, he's cited Prudential and the revenue commissioners. I'm reminded that the disgorgement figure in this case was the larger one, but...
5%, and the other one is 5.09.
I'll come back to that. Just very briefly, Prudential and the revenue commissioners, Authorities Bundle 7, tab 70. I don't ask you to go to it now, it's page 3831. If you look at that decision, the issue was, it was a claim by a taxpayer against the tax authorities for reimbursement of wrongly charged tax. And one of the questions was, what interest do you get? Is it Section 35A, Superior Courts Act interest, or does restitution entitle you to interest as a sort of substantive remedy, compound? That was the issue. The analysis in the House of Lords was that where money has been paid under a mistake, a debt claim arises for repayment. Because the nature of the remedy was a debt claim, the House of Lords said, Supreme Court said, Section 35A interest, thank you very much. That's all it's saying. It is not making a general statement of law that in no circumstances can interest contain an element of disgorgement. Compound interest against a defaulting fiduciary does contain an element of disgorgement. There are situations in which interest does contain different elements. The Prudential case is not a decision for all purposes in all contexts. Similarly, the Bark-Kayser case that Milan Friend went to, Mr. Justice Steyn at first instance, you will have seen that the passage that he read contains twice the expression, in a case such as the present, ... Again, it is a decision on interest that is appropriate in a claim of damages by a bank against an insurance company. It is not laying down a blueprint of principles for all interest claims in all situations. And so, in our submission, Milan Friend has offered no principled reason why the legislation of the Cayman Islands should be interpreted in a way that ties the exercise of the discretion under 238.11 to the differently worded pre-existing discretion under Section 34 of the Judicature Law. And for those reasons, Milan Friend has established no point of principle on which the first instance and the Court of Appeal can be overturned in this case. So, Lords and my Lady, unless there are any other points, I've left my landed friend his allotted time.
On an interest, is it not a material point also that as a result of the occurrence of the effective date, the shareholder no longer has any shares before the sale is completed? He can't raise money or on the security of his shares and so
yes, that I hadn't thought of that, and yes.
Whereas the company can go ahead and implement its plans.
Absolutely, exactly. The whole dissenter process doesn't hold up the company doing whatever it wants, exactly so. I'm grateful.
Yes, thank you very much. Mr. Jones.
Yes, well, it's no different to any other case where some money should have been paid earlier. My own friend to say, well, this ought to be given some different principle because it would provide an incentive. Well, that would be an incentive in every case where somebody doesn't pay money. The fact that property is passed in a contract where the payment should be made at that time according to some formula, and they can't agree what the formula is, that's exactly what we've got here. It simply can't justify having a disgorgement of the benefit here and not anywhere else. That was rejected in the Prudential case. It quoted from the statement the purpose of interest, and it's not just interest under a particular section, it's the purpose of interest. It comes from the word. The purpose of interest is to compensate the person who's out of money. Of course, if there are fiduciary obligations, we know that there are different principles that apply. And of course, there can always be particular facts in any particular case, but this case wasn't decided on any particular facts. It said the starting point in all cases was that you took the benefit that the defendant received and you took the rate that the centre could have obtained. That's how you must do it. And then you split it down the middle. That isn't an unprincipled basis. You cannot justify the disgorgement of the profits, and therefore what it comes down to is whether the correct principles were applied for calculating the compensation element of the dissenter. And that simply brought him a sum that he would have obtained had he invested it in the corporate bonds. But the correct way to do that is you have to appreciate that the non-payment doesn't cause that loss, which is why the correct starting point is the borrowing costs of the claimant. So I can assist you further. We've done that to the minute.
Right. Thank you very much indeed, Mr. Jones. Well, although the points in this case are fairly technical, they're also of considerable interest and also considerable importance. We'll take time to consider the submissions on both sides and decide what advice we will humbly tender to Her Majesty.